You hear me in the jail? They're not really responding. They have it on mute and they have the volume off. He was brought into the virtual courtroom, but he wasn't close, so my staff put him back in the waiting. So I'll call the case on the record in the matters of the people of the state of Michigan versus Hot Banyan, 22-03449 and 23-00102. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Attorney John Abbott with the Public Defender's Office representing Mr. Nguyen this morning. Please not present.
Okay, today is the date that was scheduled for probable cause conferences in both matters. To be clear, Mr. Nguyen may be present because the Ingham County Jail tablet is here. I think due to the nature and condition of his mental state, he was in a different room on a jail tablet. But they were not able to successfully get him appropriately clothed for court. And so my staff put him back in the waiting room. They were advised by Ingham County that they would attempt to get clothes on it, but I don't know if that's happened. So I'm happy to proceed in this form without his presence and waive his presence for this purpose. My understanding that there's a request for competency.
Yes, Your Honor. I'll defer to defense.
That's correct, Your Honor. It's my understanding that he's identified as a person requiring treatment from the sheriff, and also would like to submit a petition for competency to criminal responsibility.
And for the record, it was also indicated by the magistrate that there was some competency concerns at the time of arraignment. So the court will note that the defendant is going to undergo competency evaluation. And so the 21 days on this is supposed to be scheduled for an exam, not. I don't know why it says probable cause on. Am I on the wrong files? I'm not. Hot. Yeah. It says on the docket probable cause, but this is definitely supposed to be an exam date. He was arraigned on the 20th. PE was supposed to be tomorrow. We moved it to today. So the court will go beyond the 21 days, obviously, because this matter is going to be referred to evaluation at the Center for Forensic Psychiatry. Both matters, and you're going to submit that paperwork at another time.
Yes,
you have it
sir.
with you now. Okay. Any additional matters for today's record?
Not for the people, Your Honor.
Not committed offense.
Thank you. You're all set. Mr. Palmer is going to run call. Let's see. Is Nathan Norris here? On the record in the matter of the people of the state of Michigan versus Nathan Anthony Norris, 25-00880.
Good morning, Your Honor. Matt Nagel for the people.
And I see Nathan Norris is present via Zoom without counsel, and my understanding is that you were denied public defense representation because you are not indigent. So you have the right to appeal your denial and provide further information that you think may have been missed or things that may have changed your financial status, or you can hire your own attorney at your expense, or you can waive counsel. However, you are being charged and proceeding on a felony matter. So you're facing the maximum on count 1, 2 years and or $2,000 in fines. You understand that, sir?
Yes.
Okay, how would you like to proceed as it relates to your representation?
I would like to, you said my financial situation changed. I have a lawyer. I got my days mixed up, so I was going to put my retainer fee down, and I didn't realize it was today. So
Okay, so you are gonna retain an attorney. What attorney is that?
Michael Oates, I talked to him. He already had court this morning and everything, and I mixed my days up. I didn't realize. I don't know why I thought it was tomorrow.
Okay, so you're currently scheduled for preliminary examination before me in person at the court, April 10th at 8:30. We'll continue to exam at this time. And Mr. Oaks will let us know if we need to address the timeline at that time, okay?
All right.
Do you have any questions for today?
No.
Any additional matters for the record?
No, Your Honor, thank you.
You're all set for today, Mr. Norris.
All right. Thank you.
You're welcome. Is Clarence Simmons here?
No, he's not.
On the record in the matter of the people of the state of Michigan versus Robert Jordan, 24-02460. Appearance for the record.
Good morning, Your Honor, Matt Nagel for the people.
Good morning, Your Honor. Assistant
Jeff Kaplan, P 74943, on behalf of the defendant who's standing to the right.
Today was the date scheduled for sentencing for Mr. Jordan. Let's see here. Have a pre-sentence report. It was prepared back on the 27th of March. Did you get a copy of that, counsel?
I have, Your Honor, and I've had a chance to review with my client.
You need to make corrections, updates, or deletions.
Not for the defense, Your Honor.
Thank you. You can make allocation.
Your Honor, I'm not going to belabor the point. This is my client's very first offense. The recommendation here is for 6 months of probation, anger management. My client was immediately regretful of what happened. This was sparked by a medical issue my client had. He thought his downstairs neighbor was not respecting the fact that he was sensitive to loud music, which the neighbor was playing, and my client, like I said, he overreacted. He knew he shouldn't. He immediately apologized. And I'm sorry, I shouldn't say immediately apologized, but he immediately acknowledged with the police that he shouldn't have reacted the way he did. We're asking that you just follow the recommendation, sorry. And the only thing that I would question, Your Honor, is the recommendation also includes randomized urinalysis testing. This incident didn't involve drugs. I don't know what the purpose of the testing would be for as it relates to the crime. So it asks that you strike that.
Your client want to make a statement.
He said he did not change your mind at all.
Only that I'd apologize if I could.
The victim is not here today, correct?
That's correct.
I reviewed your pre-sentence report and recommendation. This is again your first offense. Easy for the court to assume that this is an isolated incident.
Will remain so.
Yeah, and that this was something that was prompted by maybe a number of circumstances. I don't know if this was an issue where you had an ongoing issue with the neighbor. Things could build up and then due to your medical issue, it exacerbates things at times. Hopefully you've gotten all of that under control. I think the recommendation is appropriate for a short term of probation and oversight. I don't see any you're not employed.
No, I'm disabled, Your Honor.
Oh, you from Boston?
Born there, Your
Where?
Honor. Fall River.
You're from Fall River. I'm from Boston. I think we got an attorney from the area too on here. So a couple of Massachusetts people. Okay, I get it. Okay, so I agree. I don't see anything in this pre-sentence interview that would make me believe that alcohol was an issue or substance was an issue. So I won't require testing at this time. If for some reason that information comes to the court that needs to be some oversight as it relates to substance, and it'll change. So the order will be 6 months probation. You're not to engage in any assaultive or threatening behavior while on probation. You're not to be at any bars or nightclubs while on probation. You are not to purchase or possess a firearm, ammunition, or weapon of any kind while on probation. And you're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. I'm not going to require submission to testing at this time. I'm going to order that you complete anger management during your probationary period. And I'm going to order you complete 40 hours of community service. 10 of those hours must be completed at the LMTS Outreach Center in Lansing. You can get a list of other approved places for the remaining 30 hours from your probation officer, okay? Okay,
Yes, Your Honor.
okay. There's a $30 per month oversight fee that you're responsible for while on probation. There's a $75 crime victim right with a $50 state minimum cost per file, per count that is. I'm gonna waive discretionary fines and costs at this time. $155. And you will make or can make monthly payments on that, okay?
Yes, sir.
Last but not least, there's an advice of rights as to probation. You have the right to request, Yolanda, you have the right to request early discharge from probation once you've completed half the original term ordered by the court. So long as you've completed all of the requirements, that would be your anger management and your 40 hours of community service. You can make a request after you've completed 90 days, so long as you're not having any violations as well, okay?
Yes, sir.
You can get the form for your request for early discharge off the court website. It's the NC 512 form. Or you can request a copy from it from your probation officer. Your probation officer may also make the request on their own for you to be early discharged if there's been no issue. And that you've completed all the program, okay?
I understand.
If I set it for a hearing for whatever reason to address your request for early discharge, you have the right to hire an attorney to represent you for that hearing. You do not have the right to court-appointed counsel for that hearing, okay?
Yes, sir.
Do you have any questions about that?
No.
Going to continue the no contact order with the victim as well. Samuel Stark. I recognize you all are still neighbors.
No, we're not.
Okay. So you're still not to have contact director and directly with him, should you run into him somewhere. You're aware of that, okay? You're just gonna initial that paper indicating that you've been advised of those rights. You're gonna check in with probation on your way out of here, and then you'll be all set for today. Thank you. Any additional matters for the record?
After the fence round, you're gonna get that. They just need acknowledgement to receive it.
He needs a copy of that.
Oh, she's gonna get them? Okay.
If you want a copy, she can make a copy.
Thank you.
No problem. Okay, let's see. Is Shaya Reed here? She is?
Yes,
What's her attorney? Is it Kareem Johnson? We've not seen her. We have not seen your attorney, Ms. Reed. Let us see if we can locate him. Who's in the
Okay.
jail? Who's in the jail?
Johnson,
What's your full name?
Michael H. John Johnson.
Thank you. That's Ms. Donnelly's client. Looks like. Okay, let's see. Giannina Ballerini doesn't have an attorney?
I don't know if they were able to.
She doesn't have court-appointed counsel? On the record, in the matter of the people of the state of Michigan versus Giannina Ballerini, 25-00893, counsel appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Okay, Ms. Ballerini is not here today. We do have some indication here that she may be in the custody of a mental health facility. I also have a note that there was some trouble arraigning her at the first stage, and then that she was eventually arraigned while at Sparrow Hospital. I would imagine due to that, that there was not the ability for the public defender's office to do any of their paperwork or have a private meeting with her. So due to that, the court's going to go beyond the 21 days to reset this. Actually, we'll shoot next week as PCC. It's scheduled for exam next week. That way we can maybe get an update as to where she is. Got the record on that matter. The record in the matter. I need to find, read at some point. People of the state of Michigan versus Stephen Sanderson or Facebook to put him on.
I didn't crop that one out yet. He talked to Charlotte and they're just leaving it on.
Oh, okay, I saw her on here. I didn't know what she was putting her appearance on. The record. So that's gonna
She
continue.
heard, Simmons.
Yeah, why don't you check it, I want to see Mr. Johnson.
Okay, well, you can call and find out who it is. Sanderson is continued.
Yeah.
On the record in the matter of the people of the state of Michigan. Where's Sotelo? They're supposed to put him on?
He's downstairs.
Oh, well, he can be brought up. Next, of course, must be downstairs. I've not seen Miss Donnelly, but Mr. Johnson is on. So we can find this. If we can see if we can find Miss Donnelly and let her know her client is on here. But she did not tell us what she needs to
She's
do.
checked in with me.
I would imagine you can follow up, figure out where they are, as well as contact Mr. Johnson before you go downstairs.
Okay.
By phone, not email.
Yes.
And then Mr. Sart's on the record in the matter of the people of the state of Michigan versus Matthew Luke Wolf, 24-01673.
Your Honor, may Mr. Nago and I approach just very briefly.
I got it.
So.
you show me what number you found? You can be seated. Is that from the state bar website? Okay. It was just send an email. I have no idea what in the world to do. Okay, on the record, in the matter of the people of the state of Michigan versus Matthew Luke Wolf, 24-01673, counsel appearance.
Fortuna Gill on behalf of the people, Your Honor. I'd like to make a motion for permission to practice under Michigan Court Rule 8.120.
The motion's granted.
Thank you, Your Honor.
Good morning, Your Honor. Jacob Sartz, fourth assistant public defender here on behalf of Mr. Wolf. Mr. Wolf is present at council table. He's standing to my right, and Mr. Abbott is also present on behalf of Mr. Wolf for this morning's proceeding.
Okay, today was the date that was scheduled for a preliminary examination. Do we have witnesses here?
Our officer is running late, Your Honor.
Okay, my understanding is that there was a request, I have a note here from February 21st. Mr. Wolf, you said you were going to retain counsel.
Yes, I tried to retain counsel, but the money situation I have paying rent, and water line light, and
Don't go down a list of those like every adult in here doesn't know
I'm
what they
just
are.
saying, man, it's taking.
I'm not a man.
I'm just saying, Your Honor, it's taking a toll on me, and I can't really afford an attorney.
That's why you have a public defender, correct?
Yeah, but I
Because you're indigent.
didn't feel comfortable with, I don't know his name,
Mr. Sarks.
Starks. and-
Sarks.
Yeah. I don't feel comfortable with him at all.
Okay. Without telling me anything about your case, why don't you feel comfortable?
Without telling me anything about.
Yeah, I don't want to hear anything about your case, but is there anything outside of the facts of your case or potential defense that makes you uncomfortable?
Yes, I feel like he's an ineffective counsel for me.
What makes you feel that way?
I feel like feel like he isn't defending me the way that he should defend me.
Okay, so you believe that he's not zealously advocating for you?
Using those type of words.
Okay, so you would like to, I'm sorry, take this case probably all the way to trial?
Yes,
Okay, and you don't think that that's your right? You have the right to take it to trial, correct?
yes.
Okay, so you don't think he agrees to taking this to trial, if that's what you want to do?
I don't think he's the proper person for that job.
What makes you think, how long have you been an attorney?
Over 18 years.
What makes you think that he being a attorney for over 18 years, how much of that was criminal experience?
Yeah.
18-year criminal experience doesn't make him qualified to defend you in a
I feel
criminal
like,
matter.
I feel like he's ineffective counsel for me because of what I heard and saw. I just feel like,
What you heard when you talked to him in private, you mean?
what I heard and saw. Yeah,
Is somebody in my yelling out something in the back of my courtroom? Oh,
I'm a twin, so it's just.
You're
it's just
what?
Natural. I'm sorry.
you say you're a what?
I said, Your Honor, I'm a twin. So
You're-
it was
what's your
natural
name?
for me to speak. I'm Michael Wolf.
You're Matthew's twin?
Exactly.
So when his brain moves, your mouth opens.
No, I'm not saying that. It's not that easy to explain, but what I'm saying is
I recognize you're probably protective.
No, I am, but I'm sorry.
Yeah, you can't blurt out in open court.
I know, I
Okay.
know that.
Okay, Michael is behind you, but he's gonna be quiet because you have the ability to articulate yourself, your feelings, and you should, because you obviously have the ability to determine if an attorney of 18 years of criminal defense experience is not qualified enough to represent you
I
on
didn't
this
say he
case.
wasn't qualified enough to represent somebody.
I said
just
to
said
represent,
he's
I didn't
not
say somebody, I said
qualified
you. That was what I said.
I don't think his qualifications at this point are effective to that right now. I
Oh.
think that his ineffective counsel was my effective point to where I said, I don't want you as my counsel.
What was ineffective?
The way, I can't really say it without saying nothing about the case.
I don't want to hear about the facts of the case.
Oh, no, I wouldn't say nothing.
Yeah, but you have to be
I
able to
overheard a
articulate.
conversation with the lady.
Did he fail to meet with you? Did
No.
he met with you?
I know, I'm not understanding the question.
With my question?
Yes,
My question was, did he fail to meet with you? You don't understand that?
I didn't say he failed to meet with me.
So he met with you, he went over your discovery and information with you? Is that a yes or no? This is just a yes or no question. Yes, he did, or no, he did not?
He did.
Okay, and he went over potential, defenses and potential risks with you?
No, he
No,
didn't.
now, did he meet with you before or after you decided that you wanted to retain an attorney?
No, I overheard a conversation in the hallway.
About your case?
Yes,
With whom?
the black lady is sitting right there.
You overheard Mr. Starks
Yeah,
in a conversation with my court officer.
Yeah, she said, we ain't got nothing to go on right now. And at that point,
She said we don't have anything to go on.
Yeah, because the officers weren't here. So at that point, I would have said, well, can we move for dismissal?
Oh, you're talking about a conversation you heard today?
No, this was not today. This was that day.
What day?
The day we was here for the preliminary examination on the 21st.
Okay, so you were here on the 21st. And that's the date you said you were going to request to retain counsel. And so you said the officers were not here. I don't know if the officer was here. Do you have a record of whether the officer was here?
I don't know, Your Honor. This is back in February. My notes just indicate that the defendant wanted to seek new counsel, so this was adjourned, so I.
Oh, but that was the date and time of the actual exam that he stated that. Who's the officer that's supposed to be here? Because they're not here now
And
either.
then I heard them say Then I heard him say, call Michigan State Police right now and tell them to get down here. We'll hold him and do the people that's in the jail first, and then we'll keep him at, until we do get a Michigan State police officer up here.
You heard your attorney say that
Yes.
to my court officer?
Yes.
Why would that doesn't make sense, but my court officer wouldn't call the state police. She doesn't call witnesses.
I don't know, but I heard that.
You didn't hear my court officer talking about. Mr. Sarge, did you instruct my court officer to call the state police?
Absolutely not, Your
This
Honor.
didn't make any sense. My attorney, we don't call witnesses. We don't do that.
Okay, Your Honor.
Under no circumstance.
Your Honor, I am not a liar.
I'm not saying
And
you're
I
a
would
liar,
not-
but you might be
I would not lie
misunderstood.
under oath either, because I understand that this is being recorded and everything is documented. I am not a liar, and I know what I heard. And I'm being honest with you.
I believe that you believe that that's what you heard. And if you heard those statements, let me hypothesize with you. Maybe if you heard those statements, are you sure you heard it coming from Mr. Sarge
Yes.
to my court officer? Or maybe
I don't know.
from Mr. Sarge to the prosecutor?
I don't know if it was to the court officer or a prosecutor, but I know it was a lady. I know
Okay.
that. So I
It's
can't.
possible, because Mr. Nagel may not have been here at that time. He's not been in this courtroom for that long. So, but I'm not saying, I wasn't there. I don't know what you heard, but it just doesn't make sense to me that my officer would say that, or that Mr. Starks would say it to my officer, because my court staff doesn't call witnesses here or follow up on witnesses.
I'm just telling you what
Someone
I
in
heard.
custody could go over there. It's too crowded over there.
I'm just telling you what I heard, and that's why I feel he's ineffective to me.
Okay.
I'm not saying to nobody else. and I'm not-
I can understand your concerns. If you believe you heard that, I could understand your concerns. I don't know if the witness was here. I have had Mr. Sarks before me dozens, maybe even more of times. I have never, ever not seen him. To the contrary, he's more likely than anybody else that's ever come before me to object to something. Let me tell you that. He's not letting things slide. That's not how he rolls. I have never not had a witness here, and he has not immediately argued or advocated to have a case dismissed. I've never seen it.
Mr. Sarge frequently asks if I have witnesses available, because if not, I know from experience with Mr. Sarge, he will request it.
I'm telling you, Your Honor, that he did not do this day. And that's what made me want to get a new counsel, because I wanted someone that's going to work for me and not against me.
It's in what
And I told this man.
I
that
was not
before.
there. I was not there. Mr. Sarks is an officer of the court. He stated here in open court that he did not make that statement. You're not
He's a
clear.
liar.
Don't talk over me. And don't call anyone out their name in here either. Because you may be misunderstood. I'm not saying that you didn't hear somebody say that. But I don't know that you heard Mr. Sarks say that. And he definitely would not have said it if he did to my court officer, because it's absolutely improper for my court officer to call and seek out witnesses. She would have no clue how to even do that. We don't do that. We don't get involved with witnesses. That's not our job. Witness is not here. That's their burden. They call witnesses. They follow up with witnesses when they're not here. Could be possible that Mr. Sarks is checking in, are your witnesses here? And you hear the prosecutor saying, you call Michigan State Police and get them here. That's plausible. But for me to believe that Mr. Sarks told my court officer to find a state police officer, did Mr. Sarks ever ask you?
Absolutely not.
It wouldn't
I
happen.
just know that I heard her say we have nothing to go on. And at that
What do
point.
you mean we have nothing? Why would she say we have nothing to go on? She has
I
no
don't know.
clue.
I-
She has no clue about anything going in any of this case. Do you know him?
Absolutely not.
She has no clue. She doesn't decide if you have anything to go. She doesn't know what there is to go on. We don't bring cases. The court does not bring cases. The court staff does not bring cases. The court staff does not follow up and confirm witnesses for the prosecution's office. That's completely for the prosecution to do. We do not get involved with that. You misunderstood whatever you heard. It was not my staff, and Mr. Sarks was not talking to my staff about finding any witnesses. And had you probably not came in here and requested an adjournment to get an attorney, he probably would have made a motion then. If the state police was not here, I don't know. I can pull up the record and find out if witnesses was here or not, because I can tell you exactly what happened on the record. because it was recorded. Whether or not we had witnesses here. If he knew that there was no witnesses here, he would have made a motion to dismiss the case. It's never happened before me in the hundreds of times he's been before me that he would not have, not a single prosecutor that's in this courtroom, I mean, public defender in this courtroom would not have moved for a motion to dismiss the case. It's never happened. Nor would any of them be looking or seeking out a witness for the prosecution. So you had ample time to hire an attorney if that's what you wanted to do. You do not get to pick which public defender is assigned to you. That is taken care of in-house by the Office of the Public Defender by their superior staff. Mr. Starks is more than qualified to handle your case. If the witness is here today, we can proceed today. If they're not, you and your attorneys can decide how you want to proceed today, because we are moving forward with this case today, okay? Do we have a witness here yet?
Your Honor, we don't have a witness here, so.
So I'll move to dismiss, Your Honor. Thank you.
Motion is granted without prejudice. It means that they have the right to reissue the charge against you. Do you understand that? Okay. Do you have any questions?
No.
Thank you.
Thank you, Your Honor.
You wait, you hang tight till you get a copy of the dismissal.
Your Honor,
You're welcome.
be at work at 2:30 at the code.
I'm sorry?
You'll be at work at 2:30 at the code.
You said he'll be at work?
You'll be at work, right?
You all work together too?
Yeah.
You're real twins. I can see now why you speak for him.
Came home after 18 years and 9 months. Gave me a career.
Very good. Keep staying out of trouble.
My brother saved my life.
He doesn't want to wait for his dismissal. I guess not.
But I'll take it to the file. please.
Sounds
Thank
good. Ms. Donnelly, I think you have someone on Zoom. Are you ready?
Yes, Michael Johnson, I'm ready to, I just talked to him, he might be still in breakout. Maybe. I'm here for Zoom offer, just, you can put it on the record and we'll go over it. I didn't think there was.
Who?
So.
Oh, sounds like he is in the hallway. We can give him a copy.
So we'll just leave it set for now and I'll get.
Mr. Sartz, if you want to get a copy, I think he is still in the hallway.
you. Oh, yes, please, Your Honor. Thank you.
For the record, I hired Mr. Sartz. Throwing that out there.
Listen, he got a record. He has a record of objections. I know
Oh,
that.
that's good.
I have also indicated, Mr. Sartz, that I would hire him if I gave him.
Thank you.
On the record, in the matter of the people of the state of Michigan versus Michael Johnson, 25-00908. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
And Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Stephen Freeman for Mr. Johnson, who is appearing separately by video from the Union County Jail.
Today was the date scheduled for Mr. Johnson to have a probable cause conference. And he has one count of assault with intent to do great bodily harm, DV third offense, aggravated stalking, electronic communication, and assault and battery. This matter is scheduled for preliminary examination April 10th at 9:30 in person at the court. Are we continuing?
Yes, Your Honor.
Thank you. Any additional matters for the record today?
No, Your Honor.
No, Your Honor.
You're all set for today, Mr. Johnson.
Thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Christina Jan 24-02241, appearance, please. Oh, the AG was here. Did we lose the AG? Oh, okay, there he goes.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General here for the people.
And good morning, Your Honor. Dustin Coons for Christina Jan. I'm here in person and she's appearing by Zoom.
Okay, today's a date and time scheduled for a preliminary examination. My understanding is that there's an unconditional waiver to the circuit court. Is that correct?
Yes, Your Honor.
Are the people waiving their exam, Mr.?
We are, Your Honor. Thank you.
Was there an offer?
Your Honor, we're going to work that out in circuit court. I think we're close.
Okay. Negotiations. to continue. Ms. Jan, can you hear me?
Yes, ma'am.
You understand you have the right to have a preliminary examination in this file where you are being charged with, it looks like 21 felony counts and an habitual offender notice. You understand that?
Yes, ma'am.
You understand that you have the right to have the Attorney General's office, who's the prosecutor on this matter, put forth sufficient probable cause as to each count that a felony was committed and sufficient probable cause to charge you as the person who committed each count. You understand that?
Yes, ma'am.
You wish to unconditionally waive your exam?
Yes, ma'am.
Has there been any promises extended to you to get you to waive your exam?
No, Your Honor.
You understand the waiver is unconditional. You can't get to circuit court, realize, you know what? I'm not getting the plea offer that I want. I want to have my exam now. Once you waive your exam, it's over. You understand that?
Yes, Your Honor.
I find your waiver to be freely and voluntarily made. Your bind over date is going to be April 16th. That's the date the circuit court will get the file from the district court. You do not need to appear in the circuit court on that date, okay?
Okay. So is my
Your next-
court date April 16th?
You do not need to appear in circuit court at all on the 16th. That's the date the circuit court's gonna get the file from the district court, okay?
Okay, I understand.
Then after the 16th, when they receive the file, they will process it and then they will set a next court date. That date will be a pre-trial. You will need to appear for your pre-trial, okay?
Okay, yes, Your Honor.
Let's see, your address I have on here is an address on Polk Street. Is that still accurate?
Yes, Your Honor.
On in this matter was set at 10,000 personal recognizance, and that will continue. Any additional matters for the record?
Nothing from the people, Your Honor. Thank you.
No, thank you, Your Honor.
Thank you, you're all set.
Thank you, Your Honor.
You too.
Thank you, Your Honor.
You're welcome. Okay, Miss Reed.
Yes.
We've been successful with locating your attorney, and his number appears to be not in service. Have you had contact with him recently?
No, I haven't seen him since the last court date.
Okay. I think this was conflict counsel. It was conflict counsel. I see she requested public defense. So I think this was conflict counsel. Okay, I'm gonna have to reset your sentencing, and then I'll notify the public defender's office if we're not able to get a hold of your attorney, that they need to maybe get you new conflict counsel for this purpose, okay?
Okay.
Let me get your new date.
April 17th at 9.
April 17th at 9.
I could do Zoom too.
You can.
Okay.
You're all set. Thank you, ma'am.
No problem.
record in the matter of the people of the state of Michigan versus Michael Miller, 24-00161. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Attorney Derek, Office of Public Defender on behalf of the Attorney of Record Stephen Freeman from our office.
And Mr. Miller is present via Zoom. Mr. Miller, you can hear us, correct? You're muted, sir.
Yes, I can hear you.
Thank you.
Yes.
Thank you. Today was a date scheduled for a probable cause conference. The matter is scheduled. I don't know who made these files. For preliminary examination on April 10th at 8:30 in the morning. Are we continuing to exam?
Yes, Your Honor.
Okay, was there? Okay. Any offer at this time?
There is an offer. I've conveyed this to the defense attorney. Nature of the offer, I think it's going to depend on the defense attorney's conversation with his client. So we'll revisit on the day of the exam.
Sounds good. Do you have any questions for the court, Mr. Miller?
No, ma'am.
Okay, we'll see you next week in person at the court. Any additional matters for the record?
No, Your Honor. Thank you.
Thank you.
Thank you. You're all set. Is Mr. Palmer here?
Hello?
Okay, you're free. Yep, you're free to go.
Okay, thank you.
Oh, you're covering for Mr. Palmer. Okay. State of Michigan versus William Hall, 25-00702. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
It's okay. Haley Fortuna Gill on behalf of the people, Your Honor. I would like to make a motion to practice under Michigan Court Rule 8.1.
Motion is granted for the whole day.
Thank you.
Thank you.
Good morning, Your Honor. Attorney John Abbott, the Public Defender's Office, representing Mr. Hall today for the preliminary exam.
Okay, today was,
Stay to my right.
thank you. Today was the date that was scheduled for a preliminary examination. Are we running an exam today?
Due to the unavailability of necessary witnesses, Your Honor, the people are unable to proceed, and we expect the defense to make a motion.
To dismiss, Your Honor.
Motion to dismiss is granted without prejudice. The people do have the right to reissue this against you. Do you understand that? Let's see. There's a GPS tether, so that needs to be removed. You gotta go back to Ingham County for that, okay? And that no contact order will remain in the system for probably about another 72 hours, so you should be mindful of that as well. Any additional matters for the record?
None on behalf of the people, Your Honor.
Nothing from the defense, thank you.
Thank you, you're all set.
Thank you.
You're welcome.
Thank you very much.
So. That's Sotelo, correct?
Yes, ma'am.
On the record in the matter of the people of the state of Michigan versus Felipe Sotelo, 25-00855. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Dwayne Boyd, P79612 on behalf of Mr. Sotelo. Please state your name for the record.
Felipe Sotelo.
Today was the date and time scheduled for a probable cause conference. The matter is scheduled for preliminary examination on the 10th. I just signed this substitution of counsel. Are we continuing to exam next week?
Just retained in, I haven't had a meaningful opportunity to review the discovery materials. I've asked for adjournment of 30 days. Mr. Sotelo is ready to waive his 21-day rights to the preliminary exam. I can work here with the court. It's fine.
Okay, Mr. Sotelo, you understand you have the right to have your preliminary examination within 21 days of the date that you are arraigned, correct?
Yes, Your Honor.
Okay, and due to you recently retaining counsel, he's got to get discovery, have time to meet with you and go over that discovery. You want to waive your 21 days?
Yes, Your Honor.
Anyone threatening you to do that?
No, ma'am.
Any promises if you waive the 21 days?
No, ma'am.
What's the matter? Okay. Today.
Sorry.
May 16th at 8:30. Council, does that work for you?
I believe, Judge, have a 10 o'clock in the Eastern District of Texas that day.
What time did you say?
May
He must be, yeah, he must be doing, he said Texas, he must be doing it virtually.
No, ma'am.
Oh, okay, so
Final
how,
conference in Eastern District.
so how would that work then?
May I have the 22nd?
Okay, so say, because you have to be in person for that. Okay, the 22nd
Yes, ma'am.
at 8:30, at 8:30.
Thank you.
Your notice to appear. Any additional matters for the record today?
Your Honor, may I just ask the court, this same defendant looks like he has another matter before this court. Based on
It's
some,
actually right here.
based on the conversation I've had yesterday with other parties, I'm just unsure if the defendant's been arraigned on this
It's not,
case.
it's got a note, that's why I have it, I got it already.
Okay.
Okay,
If you're, oh, I'm sorry, Your Honor, just during the arraignment, the people would just like to inquire about bond.
No worries, we'll get to that point.
Yes, Your Honor.
As it relates to file number in 885, any other matters on that file?
No, Your Honor.
Thank you.
Defense accepted.
Thank you. Okay, this is the state of Michigan versus Felipe Sotelo II, correct? Okay, 25-00926 FY. I have a felony complaint, and the complaint alleges that on,
Judge, we'd waive the formal reading, but the complaint more standing.
thank you, we don't do that in this jurisdiction. On or about June 1st, 2022, at or near the area of 529 West Howe Ave, Lansing, Michigan 48906, that the defendant did allegedly commit the act in count 1, delivery of controlled substance causing death, that he did deliver fentanyl to another person in violation of MCL 333.7401, delivery of controlled substance that was consumed by a Claire McCrae and caused his or her death contrary to MCL 750.317A. That's a felony. Maximum penalty is life or any term of years. There's an habitual offender second offense notice. Take notice of the defendant was previously convicted of a felony of an attempt to commit a felony in that on or about April 13, 2016. He was convicted of the offense of armed robbery in violation of 750.529 in the 30th Circuit Court, Ingham County, State of Michigan, and therefore the defendant is subject to the penalties provided by 769.10. That's a penalty 1.5 times the maximum sentence on primary offense or lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. You understand the charge, the maximum penalty, and the enhancement to the sentence, sir?
Yes,
You have the right to be represented by counsel. You have retained counsel who's present with you today. However, you do have the right to have an attorney with you at each stage of the criminal prosecution and the right to have counsel if you're questioned by law enforcement. And if you could not afford to hire an attorney, you could request to have the public defender's office screen you for representation by their office. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. We'll enter a plea of not guilty at this time, correct, counsel? You have the right to have preliminary examination within 21 days of the date that you're arraigned. So that's 21 days from today's date, unless you waive that 21-day timeline or the court finds good cause to go beyond that 21 days. You have the right to have the prosecution establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you as the person who committed the crime. You have the right to proceed to trial and to have a jury trial and to require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question in court any of the witnesses they call to testify against you, subpoena witnesses to testify for you on your behalf, or you can waive your silence at trial and testify on your own. Do you have any questions about your rights? You have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. What's your address? What is your address?
1224 Vermont Avenue.
1224. Repeat that.
1224 Vermont Avenue.
Vermont
Lansing,
Ave.
Michigan. 48906.
Phone number.
402-7237.
Are you employed?
Yes, ma'am.
Where?
Miller Express.
Currently scheduled for probable cause conference for me on Friday, April 11th at 9 a.m. You have a preliminary examination before me Thursday, April 17th at 9 a.m. You received your notice to appear, I see. That's correct?
Yes, ma'am.
Okay. You can address bond.
Thank you, Your Honor. As the court is aware, this case dates back to June of 2022. This defendant has been very difficult for law enforcement to follow up on during the investigation in that matter. And then as well as this other matter that just came before the court in March of this year. The defendant is charged with fleeing and eluding. During the investigation of that case, it came to investigators' attention that the defendant may have a residence in Georgia. All of this indicates a concern that the defendant is a high flight risk, Your Honor. Therefore, with respect to bond, we would ask for some form of cash bond commensurate with the risk that the defendant poses as a flight risk.
Counsel.
Mr. Hello, I think it's important to note that we had scheduled a self-surrender on April 1st with Lansing Police Department Officer Matthew Carlson. We had scheduled it for today. I had learned about the outstanding warrant when I was filling out the paperwork for my appearance and substitution judge. The LPD officer agreed that we'd self-surrender this morning. However, we do have another case in the 10th district in front of Judge Bomia, where Mr. Sotelo was ultimately taken into custody yesterday at 9 in the morning. I tried to get in contact with the Officer Carlson to see what happened to our gentleman's agreement, and I never received a response. So I'd like the court to at least know that Mr. Sotelo was ready and willing to self-surrender today in front of Your Honor. In regards to this matter, it's a 2022 case. Mr. Sotelo was recently arraigned before Your Honor approximately a week and a half, 2 weeks ago on the matter before. They had him in custody. They knew. It's a disingenuous argument to suggest that he has a home in Georgia. That is not the case. He's a longtime Michigan resident judge. He did live in Oklahoma briefly as a child. His father is in the courtroom with love and support. Judge, this is an old case. They've known where Mr. Sotelo is. They could have dealt with Mr. Sotelo when he was in custody a week and a half ago. The truth of the matter is the warrant wasn't authorized until the 27th of March, after he had been released, Judge. He's here today. He will show up for all future appearances. We're asking for a $50,000, 10% provision, Judge. We believe that that will reasonably assure the court of his appearance. And if the court has any qualms about his dangerousness to the community, we'd ask for a GPS coverage. Thank you.
sure why the prosecution or the law enforcement or of the position that there was some difficulty on your client's behalf of making communication with him during this investigation. I do see that the date of the incident was alleged to be June 1st, 2022. When I reviewed his criminal history, he looks like he was before the court on other matters in 2022 on or about the same time.
I represented him on that matter. Judge.
So I don't know how, or I don't know. I don't have any information either that he's someone that fails to appear to court. I recognize this is a situation where it's charged that alleged to cause death from a controlled substance. And so it carries life, but without some other indication. And I recognize what you're saying, Mr. Nagel, but it's not consistent with what we have here. Can you give me that other file I just gave you? He was before the court on very serious charges, more serious than this in 2022. And so it didn't sound like it doesn't appear he was evading prosecution in that.
No, I understand, Your Honor. This is information I'm getting from the investigators. I think the defense's request for a GPS tether is completely appropriate. I mean, a GPS tether would certainly put my mind at ease with respect to his flight risk.
Okay, and just to be clear, he was before the court for arraignment March 24th. It was not me, it was the magistrate that arraigned him, but should have been meaningfully noted that this was in the pipeline because he could have been arraigned on both of these. So literally sign this. It looks like 3 days after he was arraigned.
It looks like, yes, it looks like, as defense indicated, that the warrant was signed after this. I think that looks like that's correct. It looks like the warrant was probably authorized by our office on the 26th.
However, the allegations in that new file is a fleeing and eluding. So that doesn't fare well for your client. If I'm considering both sides, I don't know why the detective that was handling this newer, I shouldn't say newer, but this one, the file I'm just now arraigning him on, did not make sure that he was arraigned. It's common that when we're doing arraignments and we're on call, they let us know we got someone in custody, we have another matter. Can you review it right now? I have no idea who dropped the ball on this. I do, he has retained counsel. So that's an indication that he is invested in moving forward with this case. He participated in a homicide prosecution in 2022 with the same counsel. I don't see that there's a record of his failure to appear. So I will grant your request for 50,000, 10% bond with GPS tether.
Thank you, Judge. Will the tether conditions allow him to work?
We would hope that he would work while he's on tether. What's your work
He
hours?
typically works 6 days a week. It's 10 to 12 hours a day.
In Lansing though?
Or until the loads are delivered. I'm not sure if it's just in Lansing. I think it's like regionally, but he gets region.
It's I deliver packages, so they'll have us go to like Charlotte, Grand Lake.
Oh, within the state of Michigan, correct?
Yeah, within the state of Michigan.
Okay, because that's one of your bond conditions. You're not allowed to leave the state of Michigan without approval of the court in advance, okay?
Yes,
And you will, if you needed to, let's say you had a vacation coming up or something, you want to submit requests, you submit that through pretrial services at the circuit court. You are going to be checking in with them. You should be checking in with them when you're the matter already.
Yes, ma'am.
At least when you're not in custody. So your bond 50,000, 10% with GPS tether. You are not to use, purchase or possess alcohol or drugs without a valid prescription. You're not to have a firearm or any other dangerous weapon. You're not to travel out the state without prior approval of the court. You need to report to pretrial services within 48 hours of your release from custody. And I'm not giving you a curfew if you work. So my expectation is that you'll work and appear to all of your court dates. Any additional matters for the record?
Oh, Your Honor, thank you very much.
Thanks for satisfaction.
You're all set. Council, actually, I thought about this, and I meant to do that while I was on there, because I think we got you scheduled for 8:30 and you're out of Detroit. Would you prefer us to move that to 9:30 or 10:30?
10:30 would be great, Judge. Thank you.
Can we do 10:30? Let's see. That's fine, we'll do 10:30.
That's the one that's scheduled.
The probable cause conference for the 11th, Judge.
The probable cause conference, you can appear via Zoom. I was talking about his May 22nd. We need to move that, I guess, to 10:30, and then the 17th, we can move that back if you'd like to as well for time.
Thank you, Judge.
We do both at 10:30, the 17th and the 22nd. Okay, you're all set. Thank you.
Have a great day.
On the record in the matter, the people of the state of Michigan versus Vincent Flores, 24-097. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Attorney John Abbott, representing Mr. Flores, he's standing to my right.
Okay, Mr. Flores is here today. It was scheduled for a preliminary examination. I do have a plea sheet. States here that the people are offering for you to plead to an amended charge of disorderly drunk. You want to accept that offer?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay. I do have an advice of rights and plea information sheet that has a signature at the bottom and a date for today. Did you sign this?
Yes, ma'am.
You've gone over these rights with your attorney?
Yes, ma'am.
You understand all the rights here that you would have to give up if you wanted to accept the offer?
Yes, I do.
And you want to give those rights up, correct? So you're giving up your right to be presumed innocent, your right to require the prosecution prove your guilt by proceeding to trial and proving each element of the charge beyond a reasonable doubt. You give up your right to cross-examine or question any other witnesses that they were going to call or testify against you. Your right to call your own witnesses to testify or present evidence that you believe show a defense of this charge. Your right to waive your silence and testify on your own behalf. You understand that?
Yes.
Anyone threatening you to get you to accept this plea offer?
No, ma'am.
Any promises extended to you if you plead guilty to disorderly? You're pleading guilty to disorderly drunk because you believe you're guilty?
Yes.
As to disorderly drunk, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Mr. Flores, thinking back to it's October of 2023, you were called in on Cedar Street near the Green Lawn,
Yes.
and that's in the city of Lansing, Michigan.
Yes.
And you and your brother had been using some heroin that day. And under the influence of that heroin, you kind of staggered out into the roadway and first had to stop. Thank you. That's
Any questions from the prosecution?
Nothing on behalf of the people, Your Honor.
Okay, I accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Looks like he's been in custody on this for some time. Credit time, sir.
Thank you, Your Honor.
You're all set.